the new developments in the Karen Reed murder trial.
This has been a wild turn of events.
I've seen a lot of things. I've never seen anything like this. This case never ceases to amaze me.
It's a spectacle, that's for sure.
It was a hung jury, so no verdict, no real ending to this case.
Karen Reed was back in court where a date was set for her to be tried once again.
There are a lot of issues in this case.
Proctor was improperly searching Karen Reed's cell phone for nude photos.
Michael Proctor, the lead investigator,
relieved of his duties.
It's always the theories that each side will put forth for a jury to decide which one is more believable.
Karen Reed was drunk and angry and hit and killed John O'Keefe when she gunned it in the snowstorm.
Karen, did you ever say I hit him?
I did not.
There are more people here at the beginning of this than at the beginning of Johnny Depp's trial.
We're not concerned about any of the witnesses. None of the Commonwealth's witnesses are concerning us.
and once again, there was drama outside court.
There is a whole new set of legal troubles for Karen Reed. She is now facing a wrongful death lawsuit.
The lawsuit alleges that Karen Reed was drunk and reckless when she hit John O'Keefe.
It's not just Reed being sued here. The family also suing the two Canton bars from that night.
The two bars are liable for over-serving her.
The FBI is investigating an investigation of a murder. That never, ever happens.
At this point, multiple jurors have been reaching out to both sides, saying that they are certain Karen Reed is not a killer.
I did not kill John O'Keefe. I've never harmed a hair on John O'Keefe's head.
We're looking at arm injuries with scratches. We're not looking at tire tracks.
There are 17 jurors, and they're coming and going with a police escort.
The investigation wasn't thorough.
This can't be good for the prosecution moving forward.
I just hope justice is served for either one, whatever it is, you know.
The fate of her life is not in her hands anymore. It's not in the hands of her attorneys. It's not in the hands of the prosecutor. It's in the hands of the jury now.
Free Karen Reed! Free Karen Reed! Free Karen Reed! Free Karen Reed! Free Karen Reed!
It's been about a month since I released an episode of Conspiracy in Canton. Between the holidays and the release of other 13th Juror podcast episodes on other cases, we took a short break from the Canton saga. But just because there wasn't an episode released doesn't mean that there hasn't been plenty of drama to go around. I ended the last episode with the hopes of challenging everyone to honor the victim by not participating in the circus. But it seems that the circus has carried on and is growing more and more vicious every day. The trial that was supposed to start this month has now been delayed for a few months so that both sides can prepare. And as more motions are filed, each side seems to become increasingly more convinced of Karen Reed's innocence or her guilt. But before we dive into all things Karen Reed, including the fiery Daubert hearing that everyone is talking about, I have a few updates on some other Canton stories that we've been following that are related to the case. In episode 29, I brought up the Canton, Massachusetts ducky drama. In case you missed it, defense attorney Alan Jackson made a comment during a hearing that if it walks like a duck and talks like a duck, it's a duck. Well, the comment prompted some Karen Reed supporters to write phrases on the bottom of little rubber duckies and leave them all over Canton, in restaurants, on sidewalks, and some in front of Chris Albert's pizza place. Chris Albert then texted State Trooper Yuri Buchanan to tell him about the ducks, and it launched this big investigation to find the culprit of the rubber duckies. I was, and still am, critical of how law enforcement handled the investigation into the death of Officer John O'Keefe. I was, and still am, critical of how much effort they put into the investigation of rubber duckies compared to the effort that they put into the death of Officer John O'Keefe. It's unacceptable to me, and to many others. The state police used their manpower and efforts to track down people who left these little rubber duckies, and they were charged with felony witness intimidation for rubber duckies. A 65-year-old man named Richard Schiffler was among those charged with felony witness intimidation over the duckies. He was also charged with criminal harassment and littering, a total of 12 counts. Schiffler argued that he had a First Amendment right to support the defense's theory that Karen Reed was being framed. And on Monday, December 9th, a judge agreed with him. The charges against Schiffler were dismissed when Justice Brian Walsh ruled that his conduct and speech is in fact protected under the First Amendment. The ruling states that the reporting officer said in his summary that it was impossible for a third-party culprit to be involved in John O'Keefe's death. A wild thing to say in a trial that hasn't concluded for a case that you didn't investigate. Okay. And the judge said that there was a 6-month investigation that included search warrants, surveillance, witness interviews, and at least one confidential informant who turned over several rubber duckies to the police from a variety of locations throughout Canton. But nowhere in any of that are there any statements that the rubber duckies seriously alarmed anyone, caused serious emotional distress, or caused economic injury to the business. The charges of littering, however, were not dismissed. There are multiple witness intimidation charges that Buchanan and the state police have attempted to charge Karen Reed supporters with, and so far it doesn't seem like any of them are really sticking. The state police may not believe in the First Amendment when it comes to this case, but maybe there's still hope that the judicial system does. There will soon be an update on Buchanan's buddy, Trooper Proctor, also. On January 15th, Proctor is scheduled to appear before a Massachusetts State Police Trial Board for allegations of misconduct in the performance of his duties as a uniformed member of Mass State Police. Now, if they find that there are reasonable grounds for discipline, the colonel of the MSP may immediately impose permanent discipline. I'll include the outcome of this hearing in an upcoming episode as soon as we get confirmation of what happens. So, let's dive into the motions that have been filed for the new trial of Karen Reed. In the first trial, the Commonwealth spent 28 days calling almost 70 witnesses. The defense spent a day and a half and only called 6. But those 6 witnesses for the defense included some testimony and expert opinions that backed the defense's theory, and was apparently enough to give reasonable doubt to at least some of the jurors. It seems now like the new prosecutor, former mob attorney Hank Brennan, is wanting to do everything he can to keep the defense from being able to call witnesses who can explain and support their theory to the jury. From the outside, it kind of seems like a dirty tactic, especially when these expert witnesses were already approved and allowed in the first trial. Something that I've always thought was really interesting when watching trials is that there are qualified experts on either side that can come to different conclusions and can back up their conclusions with specific evidence and how they arrived there. It's up to the jury to decide the weight that they give to each expert and their opinions. But one of the most convincing expert testimonies from the first trial, to me anyway, was that of the ARCA experts. You'll remember Dr. Daniel Wolf and Dr. Andrew Rentschler, also affectionately referred to as the Crash Daddies. These are the guys who were hired by the Department of Justice and the FBI to determine if it was possible for John O'Keefe to have been struck and killed by Karen Reed's SUV. I did a pretty in-depth analysis of their findings compared to Trooper Paul's findings and the physics, science, testing, and logic behind their conclusions. The testimony of these 2 experts was, without a doubt, some of the most compelling evidence for the defense. They were able to conclude that the injuries that John O'Keefe sustained were not consistent with being hit by Karen's car, and the damage to Karen's car was not consistent with having hit John O'Keefe. Now, that was a big moment, and probably one of the most frustrating for Lally. So, the Commonwealth first filed a motion requesting anything and everything related to the ARCA experts. They want a complete statement of all opinions that will be expressed and the reasons for each opinion, all notes, reports, and materials relied upon when reviewing this case, all materials that were provided to the experts or any representative of the United States Attorney's Office by any member of the defense team or the U.S. Attorney's Office, all materials provided to either witness after the conclusion of the defendant's first trial, any exhibits to be used as a summary of or in support of their opinions, all compensation paid to either for all work done in this case, any contracts, agreements, or documents discussing compensation, all written communications, including emails and texts between any member of the defense team and employees of ARCA, copies of all testing not previously disclosed, including crash tests, reenactments, or any other testing materials and results, all written communications between the U.S. Attorney's Office and ARCA, and all written requests made by the defense. That's a lot. This week, the prosecution also filed a motion to exclude the ARCA witnesses based on Rule 14. So here's the deal with this. Rule 14 is all about pretrial discovery. The defendant must disclose to the prosecution and permit the Commonwealth to discover, inspect, and copy any material and relevant evidence that they are going to bring in at trial. So all of the things that they requested in the first motion, they are now saying they don't expect the defense to be able to provide. The motion to exclude the ARCA experts says that the history and complexity of the ARCA witnesses' employment and directives are, quote, muddled and unnecessary to recount for the purposes of this notice, end quote. Now, this motion is based on what the Commonwealth says they expect to happen, but not what has happened yet. So here's the deal. Rule 14 issue on ARCA came up in the first trial also. The experts are being called by the defense, but they are not defense witnesses in the traditional sense. They weren't hired by the defense team. They were hired by the federal government. That complicates things because although the TUI request was able to give both the Commonwealth and the defense access to the ARCA report, they were specifically told that they weren't able to meet with the ARCA experts to discuss their findings before trial. So the defense was unable to meet their Rule 14 obligations, which is basically what Brennan is saying he anticipates in this trial as well. Now, in the first trial, the Commonwealth argued that the defense's choice to rely on the U.S. Attorney's investigation by calling the ARCA experts as opposed to hiring their own experts was quote-unquote strategic, and it didn't alleviate them from their Rule 14 obligations. They argued that without knowing what the ARCA experts' opinions would be, they would be unable to prepare for cross-examination. This is the whole point of Rule 14, so you know what's going to be said so you can prepare. Also, based on the report they provided, Judge Canoni said that she was unable to determine who did what during their testing, and she felt like the report was not detailed enough for her as the gatekeeper to be able to determine if these guys had any credible, competent evidence to put forward. So, rather than exclude their testimony on a Rule 14 technicality, Judge Canoni held a voir dire with both experts before they were brought in to testify. Now, during the voir dire, the experts were able to testify to who did what, who was responsible for different things, what items were reviewed, is that the totality of it, what was provided to them during the course of their analysis, etc. This is the Rule 14 information that the Commonwealth was seeking so that they could prepare. Now, the judge and the Commonwealth were satisfied with this during the voir dire, so the ARCA experts were allowed to testify to what was on their report, about their testing, their conclusions, etc. Now, there were 4 conclusions total that they came to. However, their testimony was limited here. The 4th conclusion stated, quote, "There is currently insufficient evidence to determine the cause of Mr. O'Keefe's skull or brain injuries or the circumstances surrounding the event," end quote. Now, Judge Canoni ruled that biomechanical engineers are not qualified to testify as to medical causation of an injury. Only an MD can do that. There will be a lot more about that later in this episode. But the overall ruling was that the other conclusions were permissible, and ARCA experts were allowed to testify. So how is this time different? Well, it seems like Brennan is hoping to exclude any testimony that the defense has that goes against the Commonwealth's own theory that's being presented. So where the Commonwealth and the judge both got what they needed during the first trial, Brennan seems to be almost using a technicality to try to keep their testimony out. There will be a hearing on this next month, and we'll find out if the ARCA experts are going to be allowed to testify or not. Another hot topic right now is the testimony of digital forensics expert Richard Green. Now, Green testified in the first trial about the Celebrite report that shows the Google search at 2:27 a.m. on Jen McCabe's phone. Green's affidavit prior to the trial explained that he used Celebrite, Axiom, Belka SoftX, Sanderson SQLite, Forensic Explorer, and Cellhawk to forensically examine the data images of Jen McCabe's phone. He explains that he believes the Celebrite report that shows Jen Googled how long to die in the cold at 2:27 a.m. is accurate, and he explains why, and he says that he independently verified it using a low-level analysis of the artifact in the wall file, and the raw time data confirmed the search at 2:27 a.m. He explains further that evidence shows that Jen was definitely on her phone and active at that time, and he kind of goes through all of that. Now, this expert for the Commonwealth, Ian Whiffen, disagreed and gave his explanations about why he reached his conclusion. It was argued that when forming Whiffin's analysis, he didn't use the same iPhone or iOS version that Jen McCabe was using at the time, but Green did. So as in all cases, the jury heard both opinions, both arguments, the very technical explanation for their opinions, the arguments on cross-examination, and then they gave weight to whatever they thought deserved it. Now, Brennan has filed a motion to have Richard Green excluded from the next trial. He has a report from their expert, Ian Whiffin, and has included it in the motion that is basically telling the judge, my expert says their expert is wrong, and we don't want the jury to hear what he has to say because it will confuse them. Now, the prosecution says that there's a new version of Celebrite that now produces a report of Jen McCabe's phone that no longer shows the 2:27 a.m. search, which they say discredits Green's analysis. The defense has not yet filed their response. They are expected to file a response in the next 2 weeks. So the Google search at 2:27 a.m. is one of those hot button topics of this trial that has been a source of contention between everyone involved right from the beginning. I said in the very first episode of this series that the Google search was the first thing that made me stop and question things. It was the first piece of evidence that I heard that really made me just stop and want to dig in to analyze everything. But I've also said that after hearing all the evidence in trial, the 2:27 a.m. Google search isn't a determining factor for me saying that there's reasonable doubt. Celebrite is the most relied upon program in the phone data biz, so there has never been a reason to question it before. This is a big first in all the cases that I've covered, and I wanted to know why all of a sudden now we can't rely on Celebrite for this, but we can for that, or whatever. So I did an episode where I talked to multiple programmers and coders who had not heard of this case, and I asked them to explain it to me like I'm a toddler. Now, their conclusions were that it happened. Other experts who have discussed this case concluded that it didn't. For some, the Google search is just another suspicious happening in a sea of suspicious happenings. Between butt dials, destroyed phones, tons of changing statements, wrong times on reports, it goes on and on and on. Now, the defense can argue that Jen McCabe testified that she was searching how long to die in the cold, and she didn't look at the answer because they began moving John's body. Now, I pointed out in a previous episode that they moved John's body 10 minutes before that. John had been in the ambulance for 10 minutes by the time that she says she was told to Google how long to die in the cold. Also, Flamatti's report said that they had already had John in the ambulance, opened his airways, suctioned fluid, and intubated him at 6:22. So what Jen McCabe testified to doesn't add up. Now, in other versions of the story, Jen said that she was with Karen in the back of a police cruiser when it happened. But the police cruiser dash cam doesn't catch Karen screaming for her to Google this. Now, she also said that it happened when Karen looked and saw them working on John and freaked out. But again, John was already in the ambulance. So if it's not on the dash cam and the versions of the story don't make sense, the defense can argue that it couldn't have happened at the time that Jen says it did, or at 6:23, because it would have been caught on the dash cam in the patrol car that Karen was sitting in. The defense can also argue that it was searched by Jen McCabe at 2:27 for nefarious reasons, and that supports the third-party culprit defense, which may or may not give jurors reasonable doubt. So that's if the search is left in. Now, let's say the Google search is left out of the next trial. Let's say we accept the Commonwealth's timestamp of 6:23 a.m. Karen freaks out and asks Jen to Google how long to die in the cold because she has just found her boyfriend in the snow, freezing, and she's panicking because she thinks that he's dead. Suddenly, the Google search becomes absolutely nothing of evidentiary value. Just another thing that happened in the timeline that nobody thinks twice about. Now, would that really make that much of a difference to the defense's case? Or could leaving out the Google search actually help the defense's case? Let's look at this logically. It seems that when the defense presented their theory that the Alberts and McCabes could be responsible for John's death, along with that theory came a big shift in the burden of proof. Suddenly, this case became an either-or scenario. Everyone wants everyone else to choose one theory or the other. You either believe Karen is guilty or you believe that the Alberts and McCabes are. And you have to accept one of those theories, full stop, all inclusive. One or the other, pick a side. The problem with that is that it shifts the burden of proof to the defense. So instead of looking at the case and weighing the evidence to determine if there is proof beyond a reasonable doubt that Karen Reed hit John O'Keefe with her car, now it seems like people are relying on the defense to prove that the Alberts and McCabe's did something, because otherwise it has to be Karen. I've been covering this case on this podcast for, a year and a half, almost 2 years. There's no telling how many hours I've spent researching, interviewing, reading documents, watching testimony, rereading documents, etc., etc., etc. So I'm fully in with more details of this actual case than the average person, especially the average person who is going to be selected as a juror. Now think about this. When a random person who knows nothing about this case is presented with two theories, either the angry girlfriend did it, or his friends did it and they're working with the cops to cover it up, that would generally be a very easy choice to pick which of those on paper is more likely. But if a random person who knows nothing about the case is presented with the theory that the girlfriend did it, and then told by expert after expert and doctor after doctor that the victim's injuries don't support that theory, you're no longer looking at picking a side that's more likely. You're just left realizing that there's reasonable doubt, that there could be some other explanation that could account for the injuries and the damage to the car not lining up. It puts the burden back on the prosecution and lets the jury focus on the facts of the case against Karen as opposed to the case against the Alberts and McCabe's. Leaving out the Google search might actually be a good thing for the defense. We'll be right back after this. You ever heard the old saying, New Year, New Me? The gyms are packed full every January, but by February, not so much. It's good to set goals, but only 8% of people will stick with their resolutions all year long. But with Acorns, you can make your resolutions automatic. You can lock in years and years of healthy money habits in just 5 minutes. That's all the time it takes to open your account and start automatically saving and investing your money, so it has a chance to grow. My resolution last year was to save more money. That's actually the most popular New Year's resolution in America, which means clearly a lot of us feel like our money is slipping through our fingers. Between streaming apps and delivery fees and tips on self-checkout machines, the list goes on. But Acorns makes it easy to build an automatic routine. Today's episode is sponsored by Acorns. Acorns makes it easy to start automatically saving and investing so that your money has a chance to grow for you, your kids, and your retirement. You don't need to be an expert. Acorns will recommend a diversified portfolio that fits you and your money goals. You don't need to be rich. Acorn lets you invest with the spare money that you've got right now. You can start with $5 or even just your spare change. You don't have to feel like financial wellness is impossible. Acorns gives you small, simple steps to get you and your money back on track. Head to acorns.com/brandy or download the Acorns app to start saving and investing for your future today. Paid non-client endorsement. Compensation provides incentive to positively promote Acorns. Tier 1 compensation provided. Investing involves risk. Acorn Advisors, LLC, an SEC registered investment advisor. View important disclosures at acorns.com/brandy. And that brings us to the next expert that the Commonwealth wants out this go-round, Dr. Marie Russell. Now, Dr. Marie Russell testified at Karen's first trial, and before she was allowed to do so, a voir dire was held. Dr. Russell went through her extensive career and training. She went to MIT, Boston Police Academy, medical school at UMass, emergency medicine residency, then anatomic pathology, then forensic pathology, did tons of autopsies, became a professor, became an ER doc supervisor in the evenings, and taught legal and forensic medicine at the master's level. I mean, when I say extensive, it's extensive. She had to go through her CV and experience at the first voir dire and then again during trial. But now Brennan says that he wants her excluded. During the first trial, there were some issues with Dr. Russell being added on as a witness later than normal. She wasn't able to go through the normal pre-trial procedures and didn't have a report done at the time, things like that. So Lally wanted her excluded for that reason. Now, her testimony was allowed in by Judge Canoni, but there were limitations on it. Now, this time is different. She's not being added on late, but Brennan still wants her out. Brennan asked the court to reconsider their decision that Dr. Russell is qualified to render an opinion and says the methodology or theory underlying her opinion, particularly without any corroborating evidence, wasn't reliable. He's claiming that Dr. Russell is not qualified to render an opinion on John's injuries. He says that she is a trained emergency room physician, but doesn't have a reliable basis in the knowledge and experience of discipline to render an opinion in the field of canine bites or claw marks, or veterinary medical science, or forensic odontology, or canine behavior. Now, he goes on to say that most of her experience with canines was from 28 years ago and focused on law enforcement training canines, not domestic dogs. Law enforcement canines are trained to bite and hold, which can leave different abrasions than a dog bite if the dog bites and releases. He says that she can say how to provide care for the injuries, but not what caused them, because the jury shouldn't hear speculative evidence. Not surprisingly, the defense opposed this motion. They don't want the court to exclude Dr. Russell's testimony, and they don't want another Daubert hearing. They don't think it should be approved because it's not warranted. And they actually say it's improper and untimely, especially given the fact that they've already done this once before, and there has been no new evidence since then. But this whole thing may end up backfiring on the prosecution because with a new hearing comes new opportunities to expand on Dr. Russell's extensive experience and training, which could open up other areas that she's allowed to testify about. Now, the defense's opposition says that Dr. Russell has decades of experience as a board-certified emergency medicine physician treating patients with all manner of injuries, including 400 or 500 cases of patients with wounds inflicted by dogs and thousands of cases with injuries from car accidents or pedestrian strike accidents. Now, that's huge here. Keep in mind, John O'Keefe was taken to the ER with injuries that one side says is from a dog and one side says is from a car. Now, here's an ER doctor with tons of experience in both, and experience as a cop and first responder to these scenes. If I'm on a jury, I automatically think, I'm probably going to give some weight to what this expert says. Plus, she has published and edited several peer-reviewed publications concerning the diagnosis, treatment, and identification of dog-induced human wounds, and has been qualified as an expert in numerous federal and state cases in emergency medicine, forensic pathology, and wounds. It's hard not to think back to certain moments in the first trial when the Commonwealth would have state troopers on the stand giving their medical opinions on John's injuries. But here they have a doctor with this much experience and they want it excluded. The defense opposition is 16 pages, going into great detail about why the Commonwealth's motion should be denied. But Judge Beverly Canoni ruled in favor of the Commonwealth and had an evidentiary hearing based on Daubert. The purpose of Daubert is to determine if the expert's methodology is valid. There are a few factors that the court usually looks at. 1, whether the technique or theory in question can be and has been tested. 2, whether it has been subjected to publication and peer review. 3, its known or potential error rate. 4, the existence and maintenance of standards controlling its operation. And 5, whether it has attracted widespread acceptance within a relevant scientific community. Now, this hearing went a lot longer than originally anticipated. And like so many other issues in this case, it ruffled a lot of feathers. This hearing was set for December 12th, and the newest member of Karen Reed's defense team, Robert Alessi, gave us a good look at why he joined the team, and he was pretty impressive. He first wanted to be heard for the record. Now, this doesn't mean that what he says is going to change Judge Canoni's mind on having the hearing, obviously, but he wanted to make note of this for the record, and that's important, especially for any kind of appellate issues. So he begins by pointing out that the last time they did this Daubert hearing, the methodology of Dr. Russell was questioned, and the judge herself said that as the gatekeeper of what is to be let in, she herself approved it. Now, this is important because if she changes her mind now, She has to have good and clear reason why. Otherwise, it's on the record for this trial that she herself had approved it before. Judge Canton wants to then respond for the record and says after she made the finding that she made, she heard trial testimony, and that's why she's having this hearing now. Okay. So, Alessi is first up, and he methodically walks through the doctor's experience and training. It takes a long time, and it seems like overkill in some ways. But this is the one shot that they get. Well, I mean, okay, aside from the first time that they did this and her testimony was allowed. But this is the one shot they get this time to do this. And since the judge is allowing this hearing in the first place, it means that they have to make sure that they go through every bit of her relevant experience, methodology, training, and what makes her qualified to render an opinion on the injuries that John O'Keefe sustained. They also have to go through her opinions and how she formed them to prove to the judge that her testimony should be allowed. Again. So rather than give a play-by-play summary of 2 full days of a Daubert hearing, I want to address the main points and arguments. So first up, let's talk about changed opinions. One of the first things that Brennan kept trying to kind of push is saying that Dr. Russell changed her opinion from the first trial to now this trial. He kind of nitpicks some of the most minute things like verbiage that was used in the first voir dire and the trial when she testified and how that verbiage is changed now. So the thing is, Dr. Russell said that the arm injuries were from a dog before. She says that they are from a dog now. Her opinion on what caused them, as far as that goes, has not changed at all. What has changed is that she said before that some of the injuries were caused from a dog bite or claw, when now she has gone back and looked at everything again, and she is more specific on which injury she thinks is caused by what. So what Brennan is trying to trip her up on is the way that she said things. For example, at the very beginning of day 2, Brennan brings up a time when Dr. Russell was asked if these injuries were most probably from a dog, and she says yes. He then claims that that is different than her saying that she knows that they are from a dog with a reasonable degree of medical certainty. But Dr. Russell points out that she was answering a question here. Those weren't her words. So she tries to explain that. Now, as he nitpicks every time that she used words like probably or most likely, Dr. Russell explains that she has always been sure, but in the medical field, nothing is 100%. So she answered the questions as a doctor would. But she says nothing in her opinion has changed. Now, Alessi has Dr. Russell read back the transcript from the first voir dire where she specifically stated that she believes to a reasonable degree of medical certainty that these injuries were caused by a large dog, which is the same opinion that she has today. Brennan walks through each of the wounds on the picture of John's arm. Now, there's a basic theme here. Dr. Russell has her opinions about which of the injuries are from teeth and which are from claws. However, she explains that based on the literature and her experience, she knows that the injuries from the teeth and from the claws are often hard to tell apart because there are so many factors like the angle of the bite or scratch, the elasticity of the arm, the direction, etc. So in some of her opinions on the injuries, she says that she believes it is one, but can't rule out the other. Now, Brennan brings up the first group, he calls it wound 1. In the trial, Dr. Russell testified that she believes that those marks were caused by either teeth or claws. She said that since her opinions have been challenged, hence this Daubert hearing, like any good physician, she went back and reevaluated to check herself. She said that based on further study, she says she now believes to a degree of medical certainty that they are definitely teeth marks, and she explains why. Dr. Russell says that this is not changing her opinion because her original opinion included both. Brennan says that he thinks this is changing her opinion. I have my thoughts on it, but that would be something for each juror to decide for themselves. Dr. Russell says that wound 2 grouping is likely teeth, but she can't rule out claws, and Brennan challenges her on this one as well, saying the same thing that he said about wound 1. She had originally said it could be either, now she believes it's the teeth, but it could be claws. Brennan has been kind of rude to Dr. Russell while she's on the stand. The commentary that he includes in his questioning, it's really not appropriate for court, and there were multiple objections where the judge had to disregard his comments and have him re-ask without the commentary. When Dr. Russell is explaining her reasoning behind the determination of wound 2, he gets snarky again, and Dr. Russell, after dealing with this for hours and hours, kind of snaps back.
Did you know he was Irish? Light skin?
Makes sense with that name.
Freckles, moles. Look at these. They're all over his body. You don't think the dog was puncturing up all over here, did you?
No.
Right, so these are the same. These little things, these skin blemishes, same as these all over the body.
Oh, you're a doctor?
There's no question.
Brennan is looking at the picture and tells Dr. Russell that what she says are puncture wounds are just freckles. So she asks, "Oh, you're a doctor?" Yikes. We'll be right back after this. Now, Brennan walks through the rest of the wounds and asks specifics about what she thinks on each of the injuries and why, and he basically picks apart her answers and her reasoning. Another big point, probably the biggest in the whole entire Daubert hearing, is the methodology. So when it comes to the methodology and standards, Brennan asked Dr. Russell about the standard that she uses when deciding what constitutes as a dog bite. Dr. Russell explains that it's multifactorial. She says that it involves the pattern recognition, the configuration of the wounds, and what the wounds look like. Brennan tries to minimize her experience with this, claiming that it's just Dr. Russell giving her quote-unquote personal aside.
You have personal experience where you've treated dog wounds and you look at it and you're simply deciding whether or not to you this looks similar. You're giving your personal aside, aren't you?
I actually find that offensive.
Oh, okay. Well, is that what you're doing?
No.
Telling a doctor with decades of experience who has treated hundreds and hundreds of cases with dog bites that she's just giving her personal aside, that would be offensive. This is her expert opinion, not just a personal aside. The whole deal with the methodology is this. There are some things that have a very specific path on how to reach a conclusion. Textbook stuff. You do this, then this, then this, then arrive at this. But the doctor is trying to explain that dog bites aren't that. It's more than just one repeatable standard. The methodology is different in dog wounds because it's a wider range of what the injuries can look like. And there are multiple factors. So Dr. Russell is trying to explain that the standard that she uses isn't some kind of textbook that you compare. It's based on years of experience observing, treating, and evaluating dog wounds, plus peer-reviewed articles and other literature that is all combined to form the standard. She also uses differential diagnosis, where she rules out other causes of the injury that could have produced similar wounds. Brennan spends a long time trying to focus on the methodology part of determining that the wounds are from a dog. That's the only chance that he really gets at having this witness testimony excluded, because she's obviously a very qualified and experienced doctor. So he's trying to prevent the jury from hearing this alternate explanation by picking at the standard for determining the dog wounds. One of the arguments that he uses is that Dr. Russell says that the bite marks and claw marks are often hard to tell apart. He says that's because there's not a standard. He also argues that looking at one of the sections of wounds independently doesn't help determine if it's a dog wound. But Dr. Russell says that it's not about the individual wound, it's the collective pattern of the wounds. And she says that that is supported by the literature as well. But Brennan continues to push this. Dr. Russell is unable to give a definitive answer to a medical degree of certainty on each individual wound. She continues to explain over and over that it's pattern recognition. Dr. Russell gives a great explanation of this.
Mr. Brennan, that's the way medicine is. You know, in medicine, you don't just look at one complaint or one wound or one test and make a diagnosis. You usually need several supporting tests or other lesions to corroborate a diagnosis. So that's part of medicine.
The defense walks through a line of questioning with Dr. Russell that addresses the question of methodology. Now, Dr. Russell explains that a lot of medical practice is based on pattern recognition, and it's rooted in evidence based on medical science. There are textbooks written about this, and pattern recognition is absolutely accepted in the medical community. They go through some of the articles and literature that supports this, and then they discuss the wound patterns of a dog being pathognomonic, meaning there's nothing else that causes them. They are specific to only that cause. Since methodology is the main argument that the prosecution is making, Alessi also walks through the methodology listed in medical articles and text to support every opinion that Dr. Russell gave about the injuries and patterns, and everything that supports the methodology that she described in pattern recognition being accepted in the medical community. There are also some new things that we heard during this hearing. One thing that Brennan brought up that has never been said before or testified to is that the sleeve of John O'Keefe's shirt where the injuries were was quote unquote littered with shards of the taillight. Now, is this new information or a misstatement of facts? I'm leaning toward misstatement of facts, and here's why. We heard in the first trial from Maureen Hartnett, who testified that she performed the debris collection on the shirts of John O'Keefe. Hartnett did not say that the sleeve of the sweatshirt with the damage was littered with shards. What she said was that she took scrapings of both shirts to get any dirt or debris that was on them and put the scrapings from both shirts together in one pile, and then that pile was submitted. There's nothing in her report or testimony that specifies where anything came from on either of the shirts, because both shirts were packaged together, they traveled together, they were tested together, submitted to the lab together on March 14th, about 6 weeks after John's death, and the scrapings were done and piled together. Ashley Vallier testified on day 19 that she received the packaged debris to analyze. She looked at the debris from the two shirts under a microscope, and this is what she saw.
There was apparent dirt debris, many black, gray, blue, and orange apparent fibers, several pieces of red apparent plastic, several apparent hairs, one piece of green material, and one piece of clear apparent plastic.
This was then passed on to Christina Hanley, who testified on day 20. Hanley measured the clear plastic item at 1/8 of an inch by 1/16 of an inch and said it was found to be consistent with the taillight plastic. The red plastic measured from 1/16 of an inch by less than 1/16 of an inch and smaller, and was consistent with the red taillight pieces that they were given. So every person who testified about these items never once said anything about the items being littered in the sleeve of the gray shirt. In fact, all three testified that they were collected and put in a pile from multiple pieces of clothing that were in the bag. Another one of the things that Brennan brings up is the dog DNA testing, and he asked Dr. Russell about the absence of dog DNA. Now, Brennan asked Dr. Russell if she's aware that they swabbed every single hole in John O'Keefe's sweater and that they packaged them and tested them at UC Davis. He also asked Dr. Russell if she thinks it's remarkable that there is, quote, no dog DNA on any of those holes in the sweater, end quote. Now, this is also a misstatement of facts based on what we've heard before. On day 12 of trial, Terry Kuhn from UC Davis Vet Forensics testifies about the dog DNA samples. There were only 2 swabs that were sent in and tested. One was labeled September 6th of 2023, and one labeled September 15th of 2023, more than a year and a half after John's death. The 2 swabs that were tested showed no signs of canine DNA, though Kuhn testified that both blood and garment dye can inhibit the test from detecting the DNA, and both of those were detected in the test in this case. Also, she testified that dog claws are not good sources of DNA because they are made of keratin, which are dead hardened cells. So if the swabs that were tested were from areas of claw attacks as opposed to bite marks, there would likely not be any DNA detected anyway. Also, the state police didn't send any of the clothing to be tested. They just sent the 2 swabs. So saying that no DNA was detected on any of those holes in the sweater is misleading. The correct statement would be no dog DNA was detected on the 2 swabs that were tested. Now, another thing that's odd, on day 19 of the trial, Maureen Hartnett testifies about how she collected those swabs to be tested for canine DNA. This was her first time collecting swabs for this purpose, so Terry Kuhn explained to her the procedure that they follow. Hartnett explains that she took 2 swabs from the area around the damage. She held the 2 swabs together and swabbed the areas around where she saw the damage in the shirt. So there was 1 collection that was done for the entire shirt. She didn't mark specifically where she swabbed. She just said that it was in the areas, and she didn't use separate swabs for any of it. It was all 1 collection. There's a couple problems here. 1, Hartnett said that she held both cotton swabs at the same time and rubbed them all over the shirt. The veterinary genetics lab at UC Davis, where the swabs were sent, specifically states that only 1 swab should be handled at a time. So if they were going to do 2 swabs, it should have been done separately. Also, if both swabs were done at the same time, I'm not positive on why they have different dates written on them. Also, it was noted over and over during the trial that the clothing was in the snow for a period of time before John was found. Then it was thrown on the ambulance floor. Then it was in the hospital floor. Then it wasn't packaged properly because it was packaged together with other items. And also, when it's not packaged properly, that can lead to the induction of mold growth, which causes bacteria that eats away at DNA so that it's not detected. In this case, for all of the above reasons, the absence of canine DNA doesn't really give much insight about whether or not there was any contact with a dog. But to hear Brennan describe it, he misstates the facts in a way that makes it sound like the entire dog theory was disproven based on the DNA testing and how scientifically sound DNA is. Now, DNA is scientifically very strong evidence when it's present. But the absence of DNA doesn't hold the same evidentiary weight that identified DNA does. When Dr. Russell tells Brennan that she has questions about potential issues with the collection and transportation of the swabs and the DNA, as in with any specimen, he alleges that she is willing to come to court and just float an idea without a good faith basis or fact. Now, that's a strong allegation. Dr. Russell says that she isn't saying that there was a definite and provable issue with the DNA. She said that she considers the potential issues in her analysis. There were multiple issues that were brought up, but without being able to reference the exact report that she read anything in, as far as the DNA goes, Brennan hammers down on Dr. Russell about this being speculation. The thing about expert witnesses is that this isn't speculation. They're there to give opinions, and their expert opinions include taking into consideration possibilities that can affect the outcome of the situation. We'll be right back after this. Another thing that Dr. Russell brings up is ruling out other possibilities of the injuries based on differential diagnosis. So basically that means that she looks at the injuries and says they couldn't be caused by this, even though the wounds might look similar to some of those things. Now, during this process, Dr. Russell ruled out that the injuries on John O'Keefe's arm were caused by a motor vehicle. Brennan does not like that determination, especially since his case relies on the theory that those injuries were caused by a motor vehicle. He tries to discredit this opinion, and some of what Brennan did here was kind of frustrating. For example, he's asking this medical doctor if she was trained in accident reconstruction. He asked if she has ever gone to the scene of an accident to reconstruct what happened. He asked if she knew how fast the car was going in reverse, and if she knew the angle at which they're saying the car allegedly hit John O'Keefe, and if she looked at their accident reconstruction and the body position, and if she went to the scene, and if she was aware of a field of debris, and if she knew what the ground was like, and if she knew that Karen was saying that this was all her fault, and on and on and on. None of these things matter. She is there to give her medical opinion on the causation of injuries based on her knowledge and experience. None of those things have any impact on her medical opinion, and none of those things have any impact on Daubert standards. So it was a waste of time and snark. Dr. Russell pointed out that none of these things matter because her focus is on the injuries and the cause of the injuries, not the scene. And none of these things are relevant because she says those injuries did not come from a car. Brennan has been brought on as a special prosecutor in this case, but he's not actually normally a prosecutor. He's a defense attorney. And his line of questioning with Dr. Russell really showcases that pretty heavily. He goes through this long line of questioning about whether or not she did things, all of which are not her job and had nothing to do with her. This is usually a defense attorney tactic because to a jury, it can make it seem like this person who is only there to testify about their one piece of the puzzle isn't qualified to give their opinion. The things that he was asking her had nothing to do with her opinions or why she was there, and it had nothing to do with the Daubert hearing or methodology question either. These are things that would normally be in a cross-examination in front of a jury, not in a Daubert or evidentiary hearing, or whatever the heck this turned out to be. Another example of this is Brennan bringing up Chloe. Now, Chloe is the Alberts' former dog, and that's the dog in question that we've all heard so much about. Brennan brought up a photo of an injury from one of the people that Chloe has bit before. It's on a woman's hand, and that bite is in the process of healing, but the bite mark looks very different than what's on John O'Keefe's arm. So Brennan asked Dr. Russell, this is consistent with a tear and a pull and a hold from Chloe. Dr. Russell says, absolutely not. This is an avulsion wound, which is a very different type of wound than the ones on John O'Keefe's arm. So she says you can't really compare it. He also said something that we haven't heard before, that Chloe, who we were told was rehomed to Vermont, was located and they actually did a mold of Chloe's mouth. Now, when this happened, I have no idea. Whether or not they verified it was Chloe, I have no idea. Brennan goes on and on about Dr. Russell not comparing the mold of Chloe to the wounds on John's arm, and he talks about bite comparisons. So this is a moot point. Dr. Russell is not testifying to determine which dog caused injuries. She's testifying about whether or not it was a dog at all. That's it. She's a medical doctor, not an investigator. So the things that he's asking are, once again, irrelevant. She's determining if this was a dog or a car, not which dog it could have been. But even aside from that, bite comparison to identify bites from a specific dog, that's not really considered reliable science. Lally even handled the voir dire of Dr. Russell before and brought up articles that talked about how bite recognition isn't reliable. So for Brennan to now get up and act like it's an outrage that she didn't do this is kind of odd. There was also the bottom teeth argument. So the bottom teeth argument is something that has been brought up from prosecution, claiming that the marks on the arm don't have an upper and lower abrasion. So it couldn't be a dog bite since dogs have bottom teeth. I understand making the argument, but Dr. Russell, as well as multiple canine trainers and doctors, have explained that it is actually quite common to have bite marks only on the top. The dogs often make contact without anchoring in, so the top teeth may puncture or puncture and scrape, but the bottom teeth don't make contact, especially if the person is pulling away, like pulling their arm back if they're being attacked. During questioning, Alessi has Dr. Russell read the text that actually states this. Another argument that's made is the distance being different on some of the wound groupings. Brennan says if it's the canine teeth causing the injuries, one wound has the two abrasions closer together than the other wound. Dr. Russell said as long as the dog has healthy teeth, the teeth will be the same distance apart, but skin moves, so that doesn't really matter. Brennan also brought up peer review, and this was a crazy moment for a few reasons. First, he asked Dr. Russell if she had her opinions peer-reviewed for this case. That's not something that expert witnesses do for a trial. You're brought in as an expert, you give your opinion and your reasons, and that's it. Peer review for testimony is not a thing. Second, Brennan brings up something that we haven't heard before.
Did you know that the U.S. Attorney's Office employed a deputy medical examiner to look at these bites? And then he had commented that the wounds at 2 to 3 millimeters up to 7 centimeters were documented on Mr. O'Keefe's right arm, and the injuries do not photographically appear to be nor are described as puncture bite wounds, and thus are highly unlikely to be the result of an animal bite attack. Did you get that expert opinion from the United States Attorney's Office when they investigated this case to consider as part of peer review?
So, this is the first we've heard of this. There's a medical examiner hired by the feds who gives the opinion that the injuries are unlikely to be from a dog. Dr. Russell says that not many medical examiners have experience with dog bites or have even done autopsies with dog bites, since most dog attacks aren't fatal. So she says a medical examiner is a physician who can come up with their own opinions, but they don't have her experience. And she says that makes a difference. She also says that Dr. Walsh appears to have not recognized the pattern that she did. So his opinion on the injuries not being from a dog are, in her opinion, based on her experience and education in this field, incorrect. Now, it's interesting to hear this opinion from the medical examiner hired by the feds, but apparently Brennan cherry-picked that opinion and left out the rest. That same medical examiner hired by the feds also said this.
A vehicle backing into O'Keefe is one of many possible causes of his death, though the absence of documented injuries of his torso, hips, and legs appear to be inconsistent with a vehicle impact of significant force to simultaneously shatter a rear taillight.
So, the ME that the prosecution brings up as a valued opinion on the injuries not being consistent with a dog attack also says that the injuries aren't consistent with a motor vehicle accident. Then, in one of the most Twilight Zone moments of the day, Brennan asked Dr. Russell if she's aware of the opinions of Dr. Kenneth Kinsey, who said those injuries are not caused by a canine. Dr. Kinsey is a friend of mine. He testified in the trial against Alex Murdaugh, and I've done interviews with him for this podcast as well as for my YouTube channel. So my ears perked up when Brennan mentioned him. Then Brennan quoted verbatim the interview that I did with Dr. Kinsey.
If you look, I believe Mr. O'Keefe's arm were completely bent when he sustained the injuries. A lot of them match up. They're a continuation of another injury.
Here's the interview that he's quoting.
Those injuries, if you look, I believe Mr. O'Keefe's arm was completely bent up when he sustained those injuries, and a lot of them match up. They are a continuation of the other injury.
So here's the thing about my interview with Dr. Kinsey. Dr. Kinsey is a crime scene reconstructionist, and he is brilliant. He's testified as an expert more than 80 times in different areas like crime scene processing, latent fingerprint identification, blood stain pattern analysis, tire track and footwear identification, crime scene reconstruction. He's one of the best. He did an amazing job breaking down different parts of the testimony of Trooper Paul's reconstruction and the issues with that also during this interview. But the way that Brennan quoted this in court seemed intentionally misleading. This is a direct quote from my interview with Dr. Kinsey. He has not been consulted by Brennan, which is kind of how Brennan made it sound in court. And Dr. Russell is an MD. Her specialty is medicine. Dr. Kinsey is a PhD, and he has a ton of specialized training. But Brennan is asking Dr. Russell if she had peer review of her opinions. They have different backgrounds and different specialties. So Dr. Russell would not be aware of my YouTube interview with Dr. Kinsey in order to contact him to peer review her. And just like Brennan did with the opinion of Dr. Walsh, he cherry picks the opinion of Dr. Kinsey as well. Because in that same interview that I did, Dr. Kinsey says this about the prosecution's theory.
I don't see it from the light. I'm not saying it's not possible because, maybe that's something an engineer could tell you. And in this case, they had a very well-established engineering and crash firm. And obviously they said it didn't happen that way too. So
And he said this.
I've never seen any kind of injury like that caused by a tail lens. I just haven't seen it.
And he also said this.
I'm going to stick to my original theory. If it's not under that vehicle and it's not in the area where they found the deceased, then this whole prosecution had some problems. And they can't convince me if they didn't at least come up with a theory for that other than the tail lens did it. Because number one, if you look at the size of the victim's arm, that is too much area for a tail light. So where did all the other injuries, lacerations come from, abrasions come from? And that doesn't do it. The tail light thing doesn't do it for me.
So both opinions that Brennan gave regarding the injuries not being from a dog attack were from doctors who also said that his theory was not possible. I'm guessing he won't be calling either of them to testify for that reason. And a side note on this, if his main argument is that there shouldn't be an expert opinion in this field of dog wound recognition because there's a lack of methodology behind determining causation, wouldn't that also mean with his argument that the opinions that he's providing that the injuries weren't from a dog would also be excluded? We'll be right back after this. The bottom line here is that Dr. Russell is testifying as a medical doctor, giving the causation of injuries, not a crime scene reconstructionist or a self-defense expert or veterinary science, anything, none of that. A medical doctor giving expert opinion based on extensive experience and training of the causation of the injuries on John O'Keefe's arm. Now, Alessi points out that when people have acute injuries from a motor vehicle accident, they go to the ER. When people have injuries from dog bites, they go to the ER. And now here's Dr. Russell, an ER doctor, and she's the one who would be trained to look at these injuries and determine causation. So the hearing ends with each side giving their final arguments on the issue. Brennan goes first. His argument is that there is no methodology behind determining the wounds are from a dog. He said no matter how many times someone has witnessed or treated this, there's no methodology. He minimizes the diagnosis and calls it a personal aside. Brennan goes on to claim that despite Dr. Russell saying that she has had to diagnose dog bites before because of language barriers and things like that, that she has never been in the business of identifying dog bite wounds. She only treats them, so she should not be allowed to give her opinion on recognizing them. Brennan uses case law to support his argument. Now, this is where attorneys give the judge prior cases that were already ruled on to support their argument. The one that Brennan brings up is the case of Kara Rentala in Massachusetts. Now, I covered this case in 2023. Kara's wife, Anna Marie, was found strangled to death and covered in paint in their basement in 2010. The lead investigator said that rigor mortis had already started to set in, but the paint all around Anne Marie was still wet. They believed that Kara strangled her wife and then poured the paint to cover up any trace evidence that could lead to her being responsible. She was charged the following year. There was a trial in 2013 and another in 2014, both ending in hung juries, and the third trial ended in conviction after the prosecution brought in an expert who testified about how long it takes for paint to dry. Now, the court overturned the verdict because they found that the expert's testimony about how long it takes paint to dry was unreliable because it was only based on past experience. Kara went through a fourth trial in 2023 and was found guilty of voluntary manslaughter. So Brennan brings this case up, and he claims that it is exactly what Dr. Russell is doing, testifying based only on past experience. He says that a witness can just change their mind if it suits their purpose, and says that there's no methodology behind it, so her reasoning is just because she said so. He claims that there's no evidence to support that these are dog bites and refers to it as fertile imagination. And then he has his dramatic pearl clutching moment.
How dare she get on the stand with no experience, no training, no methodology, no facts, and ignore reality and say this couldn't have been a car collision. It's funny that as a emergency room physician, she considers the basis of mechanics of injury based on what people tell her. If they come in and say, I got bit by a dog, or a parent says, my child was bit by a dog, they rely on statements of witnesses. She didn't rely on statements of witnesses here. I hit him. Oh my God, I hit him. Maybe I clipped him. Maybe I hit him in the knee. Maybe he dropped his phone. Whatever the statements were. All the various statements. An expert like her, if she proposes to be, would consider the witness statements to try to determine the cause of mechanical injury. So for her to take the stand respectfully and suggest for a moment that this was not caused by the collision to Mr. O'Keefe, not only with no factual basis, in defiance of actual fact, it's repugnant to the sense of fairness in the courtroom. A witness, just because they have experience as a doctor, doesn't mean they can just come into court and say what they want and then let the government try to counter it. That's not how it works.
Strong language. Brennan's main argument is that there's no methodology behind Dr. Russell's findings. He actually repeats that 8 times during his closing. Brennan was quite snarky and aggressive during a lot of the hearing with Dr. Russell, a style that generally only works when you don't like the witness. But out of everything he said, the strongest argument would probably be that the methodology isn't repeatable or widely enough accepted. But that is addressed in Alessi's closing. So Alessi begins his argument and he comes out swinging.
The greatest danger to the issues in this case, the greatest danger to a defense right to a jury trial and present its witnesses to have an entire motion supported by nothing but the assertions of an attorney on the other side. That is the greatest danger to our system. That is the greatest danger to a defendant being able to present their case in their view. All of the arguments you just heard now do not come from a medical doctor, which Your Honor has said causation of an injury to a person in Massachusetts must come from a medical doctor.
That is a huge argument. The entire motion is supported by nothing but the assertions of the attorney on the opposing side. Think about that. An entire motion supported only by assertions of the attorney on the opposing side. That's huge. An attorney whose interest is securing a conviction cannot be the sole basis of what's allowed in for the defense. Brennan provided absolutely no doctor opinions to refute Dr. Russell's opinions on methodology or diagnosis, other than a clip of an interview that he found on my YouTube and a medical examiner who also said that Brennan's theory was wrong. In the last trial, Judge Canton stated during the voir dire of the ARCA experts, like I mentioned earlier in this episode, that the causation of an injury to a person in Massachusetts must come from a medical doctor. Because of that, the ARCA experts were not allowed to testify about the causation of the injuries to John O'Keefe. So Alessi brings up Judge Cannoni's own words in his closing argument, putting on the record that the causation of an injury must come from a medical doctor, not a crash reconstructionist, not a dog bite expert, and not opposing counsel. That's a strong argument. Alessi then brings up Judge Cannoni's own words again, this time from the last voir dire where she admitted Dr. Russell's testimony based on Daubert standards. That's another strong argument. Alessi addresses the case law in the Rentala case that Brennan brought up and says that Brennan missed the main point of this ruling, that the crucial issue in determining whether a witness is qualified to give an expert opinion is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. So the witness who testified in Rentala had no education and training in paint being considered fresh. He only had experience and familiarity with it. Dr. Russell, on the other hand, does have education and training as well as experience and familiarity with the subject matter. She's literally co-authored books on dog bites. Alessi then addresses the methodology being reliable. This was the biggest argument, remember? He points out that the pattern recognition is specified in different literature and reminds the court that he just walked through all of this with Dr. Russell on the examples during his questioning. He also made the point that the marks are pathognomonic, meaning they are specifically characteristic to just dog attacks. Alessi then moves on to case law. Now, the first one that he brings up is a dog bite case that his firm was involved in. It's a case that went up to the higher courts and became a part of case law, and his firm is involved in it. That's kind of a big deal, and also gives some insight into why he may now be a critical part of this defense team. In this case, the expert was found to be credible because of his experience in dog bites, as well as authoring peer-reviewed articles on it, which is basically the same situation that we're in now with Dr. Russell. This single case is probably the strongest argument that you can possibly make for this case. Here's Alessi giving the judge an example of an expert who was already found by the higher courts to be credible in dog bites based on experience and medical training. This is like telling the judge, here's the exact thing we're doing here, and the higher courts have already allowed it in and said it's fine. That's kind of a mic drop moment. Then Alessi brings up another dog bite case. This one is a federal case in Indiana where the court decided that the doctor had experience in treating the dog bites. And that, in and of itself, was enough to allow them to testify to the causation. This is another huge point. Alessi then addresses the 5 factors for Daubert, reminding the court that all 5 factors do not have to be met. They're non-exclusive, which means that's another huge point. Alessi moves on to other cases. He cites one from Massachusetts where a burn pattern expert was found to have valid methodology by simply following burn patterns. This is also relevant because it's a higher court determining that following patterns is valid methodology. The next case is a firearms case in Massachusetts, and the court determined that the judge may look to her own common sense as well as the depth and quality of the expert's education, training, and experience to determine reliability. Now, another big point is that all of the things that Brennan argued about how Dr. Russell isn't trained in odontology or veterinary science or whatever else, all of that is irrelevant. Doesn't matter. None of those professions are allowed to give their opinion on the dog bites because none of them are medical doctors. And the only people who can talk about the cause of those injuries are medical doctors. None of the professions that Brennan brought up. Alessi closes by stressing the importance of a jury having the opportunity to hear an alternate theory presented by the defense so that they can weigh the evidence and decide what they believe. The strongest part of this argument. 1, Judge Canoni has already allowed in Dr. Russell's testimony based on Daubert factors. 2, multiple higher courts have already allowed in dog bite testimony, which means there is valid methodology behind it. This isn't something new or groundbreaking that could potentially cause an issue later on. 3, there's Massachusetts law, where courts have already decided that following burn patterns is valid methodology, which kind of parallels to following injury patterns as valid methodology. And 4, the judge requires a medical doctor to give opinions on these things. And the prosecution provided 0 doctors to counter Dr. Russell's claims or methodology. The second trial of Karen Reed is shaping up to be very different than the first. Brennan has a totally different approach than Lally. He's much more aggressive and much looser with the facts. The next hearing is scheduled for January 31st, where we'll hear the arguments on whether or not Mr. Green will be allowed to testify about the Celebrite report with the 2:27 a.m. Google search. Then we may be back in court the following week to figure out what's happening with the ARCA experts. As of now, trial is set for April 1st. As we've gone through this crazy case, my mind has changed 100 times on what I think could have happened or what did happen. It's human nature to want an answer and want to know what happened and how it ends. But after a year and a half and 36 episodes, It seems like we still have a long way to go in Canton, Massachusetts. My name is Brandy Churchwell, creator of 13th Juror Podcast. If you're enjoying it, please leave us a review on Apple Podcasts and Spotify, and share this episode with your friends. For more information, photos, and episode guides, visit our website at 13thjurorpodcast.com.